So with this, we should proceed to the Indian law on broadcast reproduction. Interestingly, India's protection for broadcasting organizations came in 4 years prior to the Rome Convention, that is in 1957, with the original enactment. India started protecting broadcasting signals. Of course, at that point in time, there were no various broadcasting organizations, and all that we really had was the state broadcaster, that is Doordarshan. However, protection was existent and it was granted to the signals which were transmitted by Doordarshan. Interestingly, the term broadcast was not present, and instead the expression radio diffusion was used, and the definition of this expression included communication to the public by any means of wireless diffusion, which again is a throwback to, as we see, the Rome Convention, though the Rome Convention came later, as already mentioned. So it is pretty similar to the Rome Convention. Though wireless diffusion did look a bit restrictive, later this has been expanded, and currently the definition includes both wireless and other forms of diffusion. The interesting point is that there was a special right in all situations where a program was broadcast by radio diffusion by the government. The duration of this right was 25 years, and it extended to restraining rebroadcasts of the program, communication of the same to the public, and recordings of the broadcast. The term broadcast was expressly included in the Act in 1983, and broadcasting organizations were recognized post the liberalization of India and opening up of the private sector in the broadcasting industry. And this happened in 94. So effectively from 96 we had broadcast reproduction rights as the Act currently understands them in the context of applicability to private broadcasting organizations. There are no major changes to the scope of the right or its duration in the 2012 amendment. Therefore, one could say that it's broadly the 96 position that survives in the case of broadcast reproduction rights. Now, what is the scope of the broadcast reproduction right? A very interesting situation arose in ambience space sellers, where the pirate was using the broadcast signals and modifying the same. The pirate was blanking out the advertisements in the earlier, that is the original broadcast, and replacing it with its own advertisements. Now, this is in a sense not what the broadcast reproduction right was primarily meant to address. The idea was to stop rebroadcasters from free riding. So the whole purpose of the right is in a strong sense to prevent free riding and unjust competition or unfair competition. At the same time, the court in this particular case felt that one of the major sources of revenue for the broadcaster is what it gets from the advertisement. If the advertisements which are part of the broadcast are not protected as they are, and instead a rebroadcaster can just black out these advertisements, even if authorized to transmit the broadcasts, that would be a huge drain on the revenue. So in some sense, the court recognizes broadcast reproduction right as a broad revenue right rather than a narrow unfair competition right in the Indian context, as one can surmise from the decision in ambient space sellers. And this is also evident from the more recent decision in Delhi TV versus ICC, because here too one of the major issues was as to the scope of the broadcast reproduction right. The program which is used by ICC, which is owned by ICC, and for which there are official broadcasters, clippings from that program were used to run commercial programs, and the court categorically held that when it comes to reporting of news, it is fine and one could go ahead and use footages from the event. But when it comes to commercial programs which have their own advertising slots, then there is a fundamental problem, because it infringes on the broadcast reproduction right. Again, the philosophy seems here to not entirely worry much with the unfair competition, because here again there is no unfair competition in the strict sense, because the rebroadcaster is not broadcasting the program as it came on ICC's official broadcasters channel. Rather, it is using different footages from the program and coming up with its own program with its own anchor and people in the studio who discuss different aspects of the game and so on and so forth. So it added a lot of value, and in that sense there is no free riding. It is only use of the particular clipping to transform and create a new sort of work. In strict sense, that could even qualify as a transformative work for fair use purposes. Still, the court felt that it violates the broadcast reproduction right because the broadcast is used, or at least parts of the broadcast are used. One will have to see how this plays out in the future, and whether the fair use exception applies only in a non-commercial setting, or whether it is possible still to envisage the use of the existing broadcast in a commercial setting, as long as there is a transformative use. And a transformative commercial use, whether it would be coming within the purview of fair use or not, is something on which the law is still unclear, and Delhi TV cannot be considered a conclusive judgment on that point. It is also worth mentioning at this juncture that a lot of broadcast reproduction right enforcement today is through usage of John Doe orders. So at the time that a particular event of public interest, such as for instance the FIFA World Cup that happened this year, if there is a strong likelihood of widespread piracy during such events, the court is open to granting John Doe orders, appointing advocate commissioners who can go and search and seize equipment that is used by pirates to capture signals and thereby prevent piracy from occurring. So this is the normal method by which broadcast reproduction rights are being enforced currently. The last leg of our discussion today has to focus inevitably on a very important provision which was introduced in 2012 and which clarifies the scope of neighboring rights in general. This is section 39A. There are two important provisos here, and the scope of this shall be touched upon briefly. The first proviso here says that when the copyright or performer's rights subsists in respect of any work or performance that has been broadcast, no license to reproduce the broadcast shall be given without the consent of the owner of the right or performer. The second proviso says that the broadcast reproduction right or the performer's right shall not subsist in any broadcast or performance if it were to be an infringement of the copyright in any work. And the third important aspect of this provision is that it says that the broadcast reproduction right or performer's right shall not affect a separate copyright in any work in respect of which the broadcast or the performance has been made. So the simple question here is, if there is an underlying copyright in respect of a particular work, and then the work is incorporated as part of a cinematograph film, and then the cinematograph film itself is sought to be broadcast, how does the allocation of royalties and how does the transfer of rights have to take place effectively? Because the provision, as we see, says that there is a separate copyright in respect of the work and there is also a separate broadcast reproduction right or performer's right. So what happens to the separate copyright and how can that be enforced? The first important point of distinction here is between a copyrighted work and a performance, and the second point of distinction is between a live performance and one that has been captured on a particular medium and is subsequently broadcast. As far as copyrighted works themselves are concerned, the law is now pretty clear post the decision of the Supreme Court in Eastern India Motion Pictures Association, and then two very recent decisions, one by the Delhi High Court and the other by the Bombay High Court. And these decisions effectively say that the copyright in the musical or the literary work is separate from the copyright in the sound recording. or the cinematograph film. So once the musical or literary work has been incorporated as part of a sound recording or a cinematograph film, then all further use of the sound recording or the cinematograph film as they exist are to be done pursuant to a license which is lawfully obtained by the owner of the copyright in any of these works, and not the owners of the copyright in the literary or the musical works. In other words, there is no further right that the owner of the copyright in the literary or musical work has in respect of usage of the cinematograph film or the sound recording, as the case may be. Now coming to the second point of distinction between live performances and performances that are recorded or fixed on a medium and then broadcast. As far as live performances are concerned, the fact that there is an authorization to broadcast that particular performance will not kill the separate copyright even in respect of recordings of that broadcast. So for any use of that particular broadcast in any manner, there has to be an authorization taken from the owner of the copyright. So no license to reproduce the broadcast shall be given without the consent of the owner of the right or the performer. On the other hand, in the case of works that are recorded, that are fixed on a cinematograph film, the law then has to finally favor the owner of the right in the cinematograph film over the owner of the right in the musical work, underlying literary work, or the underlying performance, as it currently stands, for the simple reason that Eastern India Motion Pictures seems to indicate that the separate copyright will only be in respect of separate use of that work and not in respect of use of the cinematograph film or the sound recording, as the case may be. And this is borne out, as I mentioned earlier, by the subsequent decisions of the Delhi and the Bombay High Court as well. So currently the position seems to be this, but again there is no conclusive verdict by any of the courts on these provisions, that is on section 39A. So we will have to wait and see. So with this we come to an interesting to the end of an interesting discussion on neighboring rights protection, and we kind of can conclude that India's protection is as good, or probably in some respect even better, than what exists currently internationally in respect of protection of these rights of performers and broadcasters. Thank you.